Good afternoon, everybody. Thanks very much for attending King's Chambers Case Law Update. I'm Fay Collinson, barrister and mediator at King's Chambers. This is a new type of webinar that we're trialling in Chambers. So we're going to endeavour to do a wills, trust and probate case law update every quarter. So the next one's going to be at the end of Q2. I think that's going to be Matthew Hall and Nigel Clayton dealing with that. Some of you may have attended our case law updates before, and the idea really is to give you an overview of the case and point you in the right direction of some of the principles, but it's certainly no substitute for going off and reading the judgment yourself. So please do bear that in mind. This first quarter of the year has actually produced lots of case law. So it's impossible, certainly for me, on my own to cover all of them myself. So I picked just the ones that I find particularly interesting, to be quite honest. There are always lots of reported decisions on capacity trials and undue influence, Inheritance Act claims. I tend to steer away from those in case law updates just because they're so fact-specific. And in most run-of-the-mill cases in front of your district judges or your masters, you can't really take any particular principles. So I've tried to pick cases that actually enunciate some legal principles that most of you will need in practice. So the first case is Court of Appeal decision. It is a property case, although the principles in it may well crop up in your probate practice, and it's the case of Savage and Savage. And at the heart of this case is the Talata 96 Act, and it's really about Section 15.3. And I've put that provision there for you. What it says is that in the case of any other application which is made under Section 14, the matters to which the court is to have regard also include the circumstances and wishes of any beneficiaries of full age and entitled to an interest in possession and property subject to the trust, or in the case of dispute, of the majority according to the value of their combined interest. So those of you who do this type of work, and you may have made applications under Section 14 for maybe orders for sale or for declarations about somebody's beneficial interest. And when the court adjudicates that application, it will start off with Section 15.1, which sets out a variety of factors. So, for example, the purpose of the trust and various other issues that it has to consider when it's determining the application. Now, the issue that the Court of Appeal discussed was when a court is considering an application for an order under Section 14, and there is a dispute between the beneficiaries of the property trust about what should happen, can the court only have regard to the circumstances and wishes of the majority beneficiaries and not the minority beneficiaries? And the context in which this case arose was this. There were financial remedy proceedings between Raymond and his ex-wife, Vanessa. And Raymond had an interest in 3 parcels of land which were held on trust for him along with his brother's adult children, Elizabeth, Frank and Harry. Raymond had different interests in each parcel of land, but when looking at it overall, he was the majority beneficiary. The issue was, however, that Frank ran a number of businesses from these parcels of land. So, for example, he ran a campsite and some tennis courts. As part of the divorce proceedings, Vanessa wanted to seek a sale of the land, but the Raymond and his nieces and nephews were unable to agree on how that should take place. One of the complicating features was that Raymond owned a separate piece of land that adjoined these pieces of land. And the view he took was that he wanted to sell the whole lot and put the past behind him. But the other beneficiaries opposed that. And the reason for that is, I think, obvious. It's because Frank was running a load of businesses from there. So selling the land was going to leave him in somewhat of a predicament. Goes to District Judge Owen at first instance. And their order is that Frank has the right to buy out Raymond's interest before the plots of land were offered on the open market. And that's the type of order that I think, from the facts, you would expect in a case of that nature, where one of the beneficiaries is operating a business from the pieces of land and the others aren't. And the district judge held that after applying the Section 15.1 factors, he then looked at 15.3 and said that he was entitled to take account of the views of the minority beneficiaries. That was then appealed to a circuit judge, and this judge took a different view. He held that as there was a dispute between Raymond Frank and his brothers and sisters, the wording of Section 15.3 prevented the court from having any regard to the circumstances or wishes of the siblings. The way this judge interpreted it, that if there is a dispute, the only views and circumstances that are then taken into account are the majority, and you effectively ignore the minority beneficiaries. And that had an important consequence, because the order at first instance was set aside and it was replaced by an order for sale on the open market without giving Frank the right of preemption. So the effect of that was that he was going to have to move his businesses to other parcels of land, which is not always easy to do. So Frank appealed this to the Court of Appeal, and the Court of Appeal found that the district judge was correct and that the circuit judge was wrong, and so restored the first instance decision, which was that Frank had a right of preemption before the land went on the open market. And the rationale for that decision is as follows. The Court of Appeal set out that Talata, which was to replace the equitable rules regarding accounting, was intended to change the regime. And the purpose of that regime change was to give the court wide powers and discretion in relation to the trusts. And it set out Section 14 and expressly referred to the wording as the court thinks fit. So that wording, the Court of Appeal said, made it quite clear that when courts are dealing with these applications, they've got wide powers and discretion. The court then went on to say that Section 15 sets out a list of factors which the court must have regard when considering its exercise. So when you are looking at cases to advise clients under Section 14, your starting point must be to apply the Section 15.1 factors. Then the court went on to say, but those factors are not exhaustive. So the ones that are set out in the Act must be applied, but that doesn't mean that there are other ones that cannot be applied. And so the court said that the court can take into account factors not listed in Section 15 unless this is expressly prohibited from doing so if it thinks it is fit to do so. And so I've just summarised here what the effect of this decision means. So if there is no dispute between the beneficiaries, in addition to the Section 15.1 factors, the court must take into account the circumstances and wishes of any beneficiaries of full age and entitled to an interest in possession. So that's easy. But in those cases, which will probably be the ones that come across your desk, if there is a dispute between the beneficiaries about what should happen, first, you apply the Section 15.1 factors, and then in addition to that, the court must take into account the circumstances and wishes of the majority. But then the court can go beyond that. So the court is not under an obligation to have regard to the circumstances and wishes of the minority beneficiaries, but it can do if it thinks that's relevant in the specific circumstances of the case. And the court said that this district judge was right and was entitled to consider that Frank's views and his siblings' views were relevant. Case number 2, we're now moving to the Court of Protection. Case of BH and JH. I know some of you won't be Court of Protection practitioners, but statutory will case is always relevant and important in probate practices, I think. First bit of caution, it's a decision of a DDJ, which means that it's persuasive. But I think in any event, the decision is the right decision. It gives quite a thorough review of the relevant provisions. But the background is as follows. He had a statutory will already in place. It was executed in 2008. P's brother was his deputy, so he didn't have a professional deputy. P was very, very wealthy. At the time this application goes before the Court of Protection, his estate is worth around about £12 million. The will that was in place, put into place into 2008, can be summarised in this way. It made provision for a discretionary trust with a period of just less than 2 years. And transferred into that trust was £1 million plus P's property and his chattels. And then the class of beneficiaries included 4 categories. The one that we're told about in the judgment are P's carers. Then, after the discretionary trust, there was a residuary gift held on charitable trusts, and it gave the trustees the power to benefit any charity. So no specific charity was nominated within the will. The deputy brings an application to vary that 2008 will. And the reason for that was, I think, primarily because it was anticipated that notwithstanding P having a very large estate, within about 10 or 12 years, because of the extent of his care costs, his estate was going to be all but exhausted, which is quite surprising, really, even if you do have an extremely expensive care package. But anyway, the official solicitor, as you might expect, was appointed as litigation friend for P, and she agreed the variation of the will. So she agreed that it should be increased to 2 million. And it was agreed that the residuary gift should be altered slightly so that it was given to charities and said specifically for the relief of those suffering from any physical disabilities or disease caused by mental impairment. And it was also agreed that a specific clause should be removed because apparently there was an argument that would render the discretionary trust to fail, in which case the entire estate would pass to the residuary estate. So just to avoid any uncertainty in the future, it was agreed that that should be removed. And just pausing there, that is often a basis upon which a statutory will can be authorised. If there's something in a will that might lead people post P's death to having an expensive probate argument or a non-contentious probate construction claim, you can use this process to do away with that uncertainty. But here the issue was a procedural one, and it was about service and notification. If those of you aren't that familiar with statutory wills, the starting point in any application is to look at Practice Direction 9E. That sets out all the steps that you need to take, all the evidence that you need to file when you're making this kind of application. Paragraph 9 is really important. Sometimes it can get overlooked by somebody who's not hugely familiar with the process. But it makes it clear that when you make a stat will application, you must name certain people as respondents. And they must be any beneficiary under an existing will that's going to be materially or adversely affected by the application, any beneficiary in the proposed will who's going to be materially or adversely affected, or any prospective beneficiary under P's intestacy. So really anyone who's going to be adversely or materially affected by the proposal. The issue here was about service, as I say, and what had happened was the deputy hadn't bothered to notify the charities. And you say, well, the charities weren't named, so how could they notify them? Well, the Attorney General in circumstances like that can be appointed to represent the interests of those unnamed charities. And what the OS was saying was that the Attorney General should have been named as a respondent so that they could be served and for reasons of procedural fairness. But the deputy said, no, we don't need to do that because the charities aren't identified. And the reality is, when Pete dies, there's going to be nothing left that falls into the residue anyway. Where the carers were concerned, they agreed that the carers shouldn't be served, but both parties had different reasons for that. The deputy said, well, the carers are advantaged by the proposal So they're not materially or adversely affected. On the other hand, the OS said they are materially affected, but telling them about the proposed variation risks causing a conflict between them and could lead to a breakdown in P's care regime. So this is a decision of the district judge. She found that the effect of the variation was to materially affect the carers. And she said that materially should not be construed as negative in nature. I have to say, I'm not sure why the deputy ran the argument that because it advantaged the carers, they weren't materially affected. Because you have materially or adversely. Adversely means if they're negatively affected. Materially, I think, means if they're positively affected. So not really, I think their argument was pretty weak, to be honest. And so the court said that the variation obviously adversely affected the charity and that they should be notified and served. And there was no compelling reason to dispense with service. And just pausing there, sometimes there can be a real inclination or eagerness to avoid serving parties in statutory will applications because there may well be a time pressure, P may well be unwell. And I have seen people get caught out by that. I had a case a couple of months ago where the respondent was not notified in sufficient time. An urgent statutory will application was made because P was going to die within a matter of days. And the court declined to make a holding will because there had been a failure by the deputies to notify the respondent in good time. And so she was deprived of having legal advice for the urgent hearing. And the ramifications of that were so significant because P had a number of minor children that weren't provided for in the will. And the effect of it was that it went to his ex-girlfriend, with whom he'd not had a relationship for a long time. So it's really, really important to get on top of service. And also that service is not dispensed with in the COP unless it's exceptional, because everyone has a right to have their say in these proceedings. Where the carers were concerned, the court accepted that in those circumstances, it was justified to dispense with service. Because if the carers had known that they might come into a huge sum of money, then it might affect the way they cared for P, might affect the decisions, might cause animosity between them, all sorts of things. The cost decision is an interesting one. In the court of protection, costs operate quite differently to the civil jurisdiction, although the Rules Committee are consulting on it, and there is certainly an inkling that it's going to change to better reflect hostile litigation. Here, the deputy was ordered to pay the OS costs, and the reason for that was the court said that the deputy had fundamentally misunderstood the practice direction and the purpose of notification. And it was significant because if the deputy hadn't operated into that misunderstanding, then that aspect would have been agreed. And even though there was the dispute about how the carer issue had been resolved, that could have just been dealt with on paper. So it would have avoided a huge amount of costs. So now we're moving back to the Court of Appeal in the case of Braley, Shepherd and Co. solicitors. This is dealing with remuneration of professional executors. So it's quite important for those of you who are dealing with drafting wills. Mr. Braley brought third-party assessment proceedings under the Solicitors Act in relation to the administration of his mother's estate. Under her 2014 will, the deceased had appointed her brother as executor, along with Robin Shepherd, who is a solicitor, and partners in his firm at the time. Her son received a 30% share of the estate. It seems from the judgment there was some proposed litigation between the son and the estate. I think he'd intimated a dispute about living in the property, and so Mr. Shepherd had to incur costs in defending possession proceedings and things like that. And so that had led Mr. Shepherd to incur what one might say is quite large administration costs of £153,000. So that led the son to try to challenge those. The problem, however, for Mr. Shepherd was that the will bizarrely didn't include a charging clause. And I say bizarre because Mr. Shepherd drafted the will. So quite why that wasn't included, I don't know. So the issue was whether Mr. Shepherd was prevented from charging for his time spent as an executor because of the absence of a charging clause in the will. And there were two arguments that his legal team ran. First was under Section 29 of the Trustee Act, and the second was under the inherent jurisdiction. So I've just set out what Section 29 allows one to do. It deals, effectively implies a right to charge for a trustee. So they've got to be acting in a professional capacity. They can't be a trust corporation, trustee of a charitable trust, or a sole trustee. So those two aspects were fine. It enables somebody to receive reasonable remuneration out of the trust fund. And then this is the important bit. If each other trustee has agreed in writing that he may be remunerated for the services. And I've just popped down there Section 35. That's a section that means that parts of the Trustee Act apply to personal representatives. The dispute here was about whether each other trustee had agreed in writing. And what Mr. Shepherd said was, well, I've got retainer letters and invoices that have been countersigned by Mr. Hayward, who was the other proving executor. And he said that these should be treated as written confirmation of an express agreement. But there was a problem in that argument because, as you'll recall from the first slide, the partners in Shepherd & Co. were also appointed as executors. Now, none of the partners proved as executor or took any active role or sought to intermeddle. But there was another partner called Mr. Smythe. Now, he wasn't a signatory to the retainer letters or the invoices, and he retired very shortly after the death of the deceased, but didn't disclaim or renounce as executor. What Mr. Shepherd said was, well, it would be absolute madness if I had to get another executor who had no role in this administration to sign up to these letters. That's not the intention of the Act. But the Court of Appeal rejected that argument. They said that the purpose of Section 29 is to provide a safeguard for the trust or the estate in relation to the use of property to recompense a trustee or executor for their professional services. They went on to say that the section is unqualified and it refers to any and all persons who are trustees at the relevant time. So that is going to catch executors who haven't renounced but are taking no active role in the administration and who have no intention of taking any role in the administration. So that's an aspect to be mindful of. And the Court of Appeal said that the absence of his signature was fatal. Then Mr. Shepherd relied on the inherent jurisdiction, which is often relied on as a kind of catch-all scenario or power. And Mr. Shepherd argued that the court should exercise its inherent jurisdiction to authorise him to be remunerated, because he was saying, I've obviously done the work and I should be recompensed for that. And as part of this argument, he relied upon it's often called the Boardman principle, and it emanates from a Privy Council case of Boardman and Phipps. And just by way of very brief background, that was a case where a solicitor and beneficiary had entered in discussions about taking a controlling interest in a company owned by the trust. The trustees were initially going to buy it, but then the solicitor and beneficiary did instead. And they used the information they had obtained from the trustees to turn the company around, and it started making a profit. So what the action that was brought was an account for their profits made from their breach of trust in using that information. What the court did, however, was that it made a rather generous allowance for their time spent during the acquisition and the time spent improving the company. So effectively paid them for the work that they had done. But the difficulty in Mrs. Shepherd's case was an evidential one. So this case wasn't really decided on this point on a matter of principle, it seemed. At first instance, the costmaster had said, you haven't provided me with any evidence about why the deceased, or why the will doesn't provide for an express charging clause, what her instructions were about that, what her intentions were, why Mr. Shepherd should be remunerated, and the extent that he is asking for. And so this led the Court of Appeal just to set out these particular principles. The starting point is that we must remember that acting as an executor or trustee is a gratuitous office. And absent any express authorization for remuneration, they cannot be paid. And there is obviously a fiduciary duty to prefer the interests of the beneficiaries over their own. And so any exercise of the inherent jurisdiction to authorize remuneration will necessarily be an exception to these underlying rules. So the key point here is that if a solicitor has to rely on the inherent jurisdiction in these circumstances, it is an exceptional jurisdiction and it has to be justified. And here, the failing really was that the request wasn't properly evidenced. Now, if evidence had been provided at first instance, who knows, the decision might have been different. But it goes to show how it can be quite tricky to get around the absence of a charging clause. So for those of you drafting, don't omit one. So then we move to the disputed probate jurisdiction, and this is a decision of Mrs. Justice Smith. Despite me saying at the outset I move away from reported decisions on capacity, this is one that I did want to bring to your attention, mainly because of the important observations that are made about the Banks and Goodfellow test and expert evidence in the Golden Rule. It was a typical case where the claimant's children from a previous, the deceased children from a previous marriage had asserted that their father lacked capacity or lacked the requisite knowledge and approval of the will. And the new will made in 2015 gave the estate to the deceased second wife and her family. So the children were effectively disinherited. And the outcome of the case was that Mr. Leonard's will in 2015 was considered to be invalid on both grounds. I've just set out here the key points that you can take from this judgment. I've not gone into the facts because the judgment is so long. It would justify a seminar on itself. But if you're writing your letters of claim or writing a skeleton argument, and you need to have a really cogent, pithy summary of the approach to Banks and Goodfellow, then go and have a look at this case, because it's certainly one I intend to use going forward, because it does all the work for you, basically. And the relevant paragraph is at paragraph 152. And Mrs. Justice Smith addresses each limb of the Banks and Goodfellow test. And I've summarised them here for you. I won't read them all out because of time. But what she says is that the freedom to make a will means that the testator may be influenced by caprice, passion, or the power of new ties. The question is not whether the will is fair. We have to say that to clients all the time. But if the will is surprising, it's inexplicable or irrational, this may be material to the court's assessment of capacity or knowledge. And the law is not that a person suffering from an impairment has no testamentary capacity, and that can be forgotten, I think. Sometimes people will say in a letter of claim, well, on this date, the deceased was diagnosed with dementia and the will was made 2 years later. That's not a particularly persuasive argument that someone lacks capacity, but in some cases is relied on as being evidence of that fact. And this is an important thing to remember as well. Capacity is about the ability to understand. It's not about actual understanding. So you might have in a will file, we might not have evidence of actual understanding. So there might not be a record of everything the testator remembered about what their estate encompassed, because they just might not have all the information to hand at that particular time. But what she says is if there is evidence of actual understanding, then that in itself is going to be good evidence of capacity. If there isn't, then the court has to look at all the other strands of evidence from which it can draw inferences. Relevant evidence relates to the execution of the will, obviously, but also what happens before and what happens afterwards. So when you're taking your instructions, your proofs of evidence, you need to look at the whole story to see if there's anything relevant going before and after that is relevant to that issue of capacity. And then she said this about strand 2 of Banks and Goodfellow. So a testator does not need to compile a mental inventory or valuation of their assets. They need a general idea of those assets, and they don't lack capacity just because they are mistaken or fail to ascertain full details. And I often find myself saying that because, sometimes I struggle to remember where I was last week, let alone being asked, someone who's in their 70s being asked what their entire estate comprises. Some people just don't know that information. So it's important to remember that just because an attendance note records that the person couldn't recall every single detail, it doesn't mean that they lack capacity. Then she moves on to dealing with limb 3. So the testator must have capacity to comprehend the nature of the claims of others whom by the will they are excluding. And this is where she says that reference to the terms of previous wills may be a helpful safeguard when seeking to confirm limb 3 of the Banks is satisfied, but it will depend on the facts. So that's where, when we look at other wills or previous wills and what the terms were, that's where it could be relevant to limb 3 of Banks. And that's when you'd be saying to a client, well, in this will you did this and you gave to these people. So why is there now this significant change? And for those of you doing non-contentious will drafting, just making an inquiry into that and recording the outcome of that inquiry. But they're not required to be able to recall the terms of the past will or the reasons why they made it, as long as they are capable of accessing that information, understanding it if reminded of it. So you might have, for example, and I've had cases where somebody made a will 10 years before the impugned will, and they were asked about the terms of it, but couldn't quite remember. And I remember our opponents sort of jumping on that, saying, well, that shows that their memory's failing. But I think if you ask most people the contents of a document that they hadn't seen for 10 years, they would struggle to recall the contents of that. And this is the really important bit. When considering banks, the question is transaction and issue specific. So very much kind of wording that we see in the Court of Protection and under the MCA. They must have capacity with the assistance of such explanation as they may have been given to understand the particular transactions, its nature and complexity. So that's important for two reasons. In the case, it sounded like defendants had argued that capacity was more general, about the general notion of making a will rather than the specific will that was being put before that person. The judge rejected that, holding that it is about the specific will, and that has to be right. Because, for example, you might have someone who has a brain injury and they are well able to understand a very basic will that gives the residue to bit to mum, bit to dad and to siblings. But they'd really struggle to understand a will that had charitable trusts in inheritance tax saving measures and all those sorts of things. So it would mean that it would have capacity to make the first will, but not necessarily the second. The second key point to take from this is about expert evidence. And really, Mrs. Justice Smith is reiterating what has been said in previous cases, but I think she sets it out really well here. So have a look at this if you've got a case where the other side are really pushing their expert evidence. And you do sometimes get, I've had CMCs where district judges have said, well, you won't get anywhere unless you have any medical evidence. And that's just not true in these kind of cases. And I think this case backs that up. In this case, the two experts were Warner and Series, who are pretty well known psychiatrists. And what she observed was that they based their opinions upon their individual reading of the facts without knowing what findings the court would ultimately make. those opinions are not ultimately determinative of testamentary capacity. So while she wasn't criticising them, she was just observing that this is what experts do. They base their view on what's said in text messages and emails and witness statements. But ultimately, the court might go on to find that those pieces of evidence aren't relevant or don't come to the conclusion that the expert felt. And she said that both experts considered documents and identified factors from those documents as to cognitive level at which Dr. Leonard was functioning. So what she's really saying here is that the court can gain a lot of assistance from an expert analysis of medical records, obviously, scans and tests. And that's particularly important in certain types of cases. So you might have somebody who didn't have an auth or wasn't diagnosed because they just didn't go to see clinicians or their clinician missed it. And so you kind of need that retrospective diagnosis from the notes. That's where medical evidence is really useful to get that, because obviously the court can't come to that view. It can't give a diagnosis in and of itself. But where experts sort of start to stray into a remit that's not really open to them is when they look at other pieces of factual evidence. So, for example, in this case, they were looking at emails and witness statements. And drawing inferences from that to then lead to a conclusion about capacity. And that's where the court said, well, actually, that's not really an expert's role, and we can draw limited assistance from that. She said that the bank's criteria are not matters that are directly medical questions, but are matters for common sense judicial judgment, depending on analysis of the entirety of the evidence. So I think the key thing there is to make sure your expert sticks to what they're supposed to do, which is to look at the medical evidence, so records and tests and scans. But if you're relying on a report where an expert is going beyond that and looking at the factual evidence, that's where this judge is saying that is not really the role for an expert. And the final point is just about the golden rule. You'll see lots of judges say the golden rule's not that important in practice. You'll see other judges say that it is. But here the judge said that it is. So the will was prepared by a chartered tax advisor who worked in a firm of solicitors, so she didn't have any legal qualifications. The judge really, really criticised her preparation of the will and her involvement with the testator. There were obvious signs that Dr. Leonard was suffering with capacity issues and was struggling. And notwithstanding that, the tax advisor made no attempt to go and consult a solicitor in the firm or seek guidance from a superior. Another aspect that was really important was that she didn't see Dr. Leonard alone. She saw him with his wife, who was the person, along with her family, who was primarily positioned to benefit from this change in will. And she didn't apply the golden rule even when it was clear that Dr. Leonard was struggling to understand the provisions of the will. She did not suggest meeting when the instructions changed between drafts. And critically, she didn't appreciate instructions were coming from the wife, that they were coming from the wife, not Dr. Leonard. You see that quite a lot. Things being done by email nowadays. Just because an email is being sent by Dr. Leonard at gmail.com and signed by him doesn't mean it's actually from him. And there's a huge risk in taking instructions for wills by that. So what the judge said, that this lady's total lack of awareness on her part for the obvious need for caution in dealing with an elderly testator renders her views as to Jack's capacity worthless. And the defendants in this case place a huge amount of weight on the fact that there was professional involvement in the preparation of the will. But this judge found that there wasn't a proper assessment of his capacity and that the information that she was using was inaccurate. And as we know from other cases, that can lead a judge to conclude that the professional evidence is unreliable and in this case worthless. So it just goes to show that when your case, the foundation of your case is professional evidence, is to test that evidence quite early on. So I like to get those people in conference quite early on in the case, because you need to know whether they're going to withstand cross-examination, whether they're going to stand up to scrutiny, because if they're not, you need to know that quite early on. So we've got a Ray and Ray. I've just flagged that up there. I'm not going to go through it because the judgment is huge, and it's going to be addressed by my colleague Nigel at our upcoming Probate conference, which is in Manchester on the 23rd of May. Lots of you have already signed up, so if you haven't, then please do go and take a look. But Ray and Ray's Court of Appeal's observations on undue influence, which is the first time I think the Court of Appeal have actually done that in any real detail. So that will be a good one to watch. Then we move to removal of executors. So back to the High Court in Lane and Lane. It's a decision of His Honour Judge Hilliard at KC. And here it was a kind of classic dispute between family members, which had led to a very contentious removal application. There were two issues. One was about construction of the will. The deceased was in partnership with her son David in a farming partnership, and the deceased had made a gift of her share and interest in the farming partnership between herself and David to David. Then there was a gift of the residue to her daughter, Susan, and her grandchildren. In summary, because I'm just conscious of the time, it was argued by Susan, so the daughter, that her mum had lost capacity before her death, meaning that the partnership had dissolved, and so that gift failed by redemption and fell into the residue. And by all accounts, it was quite a valuable partnership. What Karen did was, as in interested party, brought a declaration that the gift had not deemed. And the court's finding was that the gift had not deemed effectively, even if the partnership had dissolved because the deceased lost capacity, she still had a right to be paid out following the winding up of the partnership. So she still had a core economic right to receive a sum produced by the winding up. So the court dismissed that. But the real focus, I think, and the most interesting bit for your purposes is the approach to the executor removal application. I think it's always quite difficult to advise clients on removal applications because they're quite risky for individuals who are acting as executors. In this case, it was effectively brought on two key grounds: the damaged relationship between Susan and Karen, effectively saying that they hate each other, couldn't work together, and it was just going to cause problems in the future. And the second was that she hadn't really done very much in the administration, hadn't been answering obvious questions that she should have done. And the court agreed with all that. And the court's criticisms of Susan were as follows. He said that she should have brought the construction claim because it was left to Karen to bring it. Now, Susan, as PR, having identified that there was a dispute about whether the gift was deemed or not, it was incumbent upon her to bring that dispute before the court and seek directions on it. And she failed to do that for a number of years, leaving it for Karen to do that. And so the judge felt that was a sort of, she's ignoring her responsibilities as personal representative. Another key aspect was that Susan's solicitors didn't respond substantively to Karen's letter of claim about the removal application or about Karen's position on the redemption arguments. And so the court felt that she wasn't really engaging in the arguments. There was also an issue about whether the estate had the benefit of agricultural property relief and business property relief. And Karen put these to Susan and said, "What's your position on this? Have you claimed them?" And Susan just ignored her. And so there was a sort of general criticism of, despite reasonable inquiries and questions being put by beneficiaries, of the PR just ignoring those. Also, the court said that whilst there had been difficulties, what it really needed to do was look ahead. And I think that's a really important point to remember in removal cases. You cannot or shouldn't be removing necessarily executor for mistakes or every mistake. That's what the authorities say, Thomas and Carville. So it may be that you have an executor who has done something wrong, but it doesn't have a material effect. It's not going to arise in the future. That is an application that you want to be rethinking if you're going to be bringing that. But you need to look at going forward. And if the breakdown of relationship is going to prevent the administration from progressing, it's going to stop people from working together, then like in a deputy removal application, that's going to be quite significant in the balancing act that the court has to conduct. And here, there were also other issues potentially about construction of the will. And what the court said was that I can see those on the horizon, and the relationship between these two women is such that they are just never going to be able to agree those because they had a strong distrust. So the court concluded that matters taken cumulatively give serious concern to the future administration of the estate, and the past administration has been lacking in a number of respects. I think the word cumulatively is quite important there, because there would be some of these that in and of themselves wouldn't be enough to justify. So, for example, not responding to the letter of claim, not necessarily answering the question about the APR or BPR. But when you take everything together, the balancing exercise fell firmly on removing Susan. There's also a second decision on cost. And again, that's quite an interesting one to have a look at. In this case, the court ordered that Susan should pay Karen's cost of the removal claim. He went on to order that if Susan didn't pay them, they should be deducted from her share of the estate. The court didn't actually set out the jurisdictional basis for that. Then on the construction claim, the court held that Susan, that both parties' costs should come from the estate. And the reasons for that were that even though there was huge criticism of Susan on the removal claim, ultimately it was an issue that had to come before the court to adjudicate on. She had taken a position, but what the court was saying here is that no one else was taking a position contrary to Karen. So the only person to do that was Susan, and the court needed to hear adversarial argument on that, otherwise it might make the wrong decision. So if Susan hadn't taken a position on that issue, then the court would have asked her to take a position. So that's why she was indemnified for her costs there. But on the removal claim, the outcome was quite different. What the court stressed here was that an executor who is removed on grounds of conduct and unsuccessfully resists the claim until judgment will normally bear personally their own costs and the other parties. And the court criticised Susan for not seeking directions on how she would deal with that. I think the difficulty with an executor in those circumstances seeking directions is that in and of itself is quite an expensive application if you're thinking about a Beddoes, and that's certainly what the Court of Appeals say in Bowser and Smith. But it just goes to show how if you are an executor and you resist your removal and you lose, the chances are you're going to be paying the costs of that. So as in the case of Reef Fullard from last year, if you are an executor and want to ensure you retain your indemnity, it's a good idea from the outset to adopt a neutral position. And just the final case, we've got Phipps and Goulburn. This was a relief from sanction application. The daughter of the deceased had found a copy of a will attached to her mum's emails to an IFA, and it benefited her. If it weren't a valid will, then the deceased estate dissolved under the intestacy provisions to her widower. The defendant, so the widower, warned off the daughter. Daughter appears to the warning. And this is where things start to go a little bit wrong. The solicitor for the claimant became unwell and had to reallocate the file to a colleague. In the November, the defendant's solicitors asked the claimant's solicitor if they're still instructed. They hear nothing, and so what they do is they apply for a summons under non-contentious probate rules, asking for an order for a grant on the basis of intestacy. And they did that because nothing was being done by the claimant to progress her challenge to that. So the court made an order, which some of you may well have sought in practice, that unless the claimant issues and asserts probate claim to prove the 2021 will within 28 days of service of this order, it was going to make a grant on the basis of intestacy. That order is served on the claimant's solicitors, and the date for her compliance was the 3rd of March. The day before, the claimant files a claim form with particulars and tells the defendant's solicitors the court's going to serve the claim form on you. Now, that was wrong because the Chancery Guide says that when you see file, it's then for the claimant to download the sealed claim form and serve that on the relevant parties. So claimant failed to do that, so missed that 3rd of March deadline, and then bizarrely missed this 4-month deadline for serving the proceedings. So she seeks relief from the sanction imposed by the unless order. And unsurprisingly, I think, relief was refused. It was suggested that the breach wasn't serious, which I think is quite an audacious submission to make, because it clearly was. It was also said that there was no good reason. The solicitor had tried to assert that the cause of it was his ill health, but actually the court went on to say the cause of the error was your misunderstanding of the Chancery Guide, paragraph 415. So if those of you who don't know about that, go and give that a read. And then on the third stage, the circumstances, the court found the circumstances didn't justify giving relief. There had been ample time in which C could have brought her claim to prove the will. It was about 3.5 years since her mother had died. The complaint was made by the claimant that, well, the defendant's solicitors didn't tell me about these deadlines and didn't tell me I needed to serve the documents. The court said, your opposing party's not under an obligation to tell you how to do your job. And this is an important point. If the relief were granted, then the claimant would need to discontinue and reissue the claim, which would cause a whole host of costs. And that the purpose of the unless order was to give the claimant one final opportunity to bring her claim. So I think the key things from this are, don't underestimate how useful seeking a summons on a claim where a claimant isn't pursuing their probate claim. So it can be quite a cheap, cost-effective way of getting a claim to go away if the claimant shows no intention of actually serving and issuing Part 7 proceedings. Obviously, if they do then do that with the unless order, it kind of precipitates those proceedings. But there are those cases where nobody's doing anything and your clients just want to crack on. So I use this process quite a bit. If you're on the receiving end of one of those processes, don't ignore it and make sure that you comply with the relevant deadlines. So that's it from me. I hope that you all enjoyed it. If you've got any questions, then do get in touch with me at my email address, which is there. But just leave me to say thanks very much for attending. Good evening.